Thank you very much, Mark. My name is Jennifer Permsley. I'm one of the co-chairs of the Dispute Resolution Interest Group under the ASIL umbrella. We cater to all persons in the ASIL membership who are interested in matters of cross-border dispute resolution and international law dispute issues. It's a large group. There's a lot of interest, and we thought that this was a very opportune time upon the close of the Supreme Court's 2017 to 2018 term to look at some of the decisions from this past year that have involved issues of international law, and we put that in quotes in our advertisement for the event because, of course, the Supreme Court is deciding issues of U.S. law, but all of these cases we've decided to focus on tonight have significant international relations or international law implications, and of course, the U.S. Supreme Court is looked at in how it handles some of these issues and how they impact our relationships and the status of foreign defendants or plaintiffs that may want to come to U.S. courts around the world. I am counsel at Skadden Arps in New York, where I practice international litigation and arbitration, and my co-moderator, Chuck Katubi, who's also a member of our interest group, is a partner at Jones Day, where he also specializes in international arbitration and litigation of international law issues. But the real stars of our show are our panelists. We have brought together a very esteemed panel. I'm very excited to have them here tonight and that they agreed to come to DC on a steamy summer evening to talk about these topics. They're all leading experts in these issues, in the U.S. court's interpretations of international law and in international law matters generally, and they've been at really the cutting edge of the front lines of some of the cases we're going to speak about tonight or the precedents to those cases. And so we have with us Professor Harold Koh, who is the Sterling Professor of International Law at Yale Law School, but also served as the legal advisor to the State Department from 2009 to 2013 under the Obama administration. Harold also clerked for Justice Blackmun of the U.S. Supreme Court, so has a bird's eye view into the Supreme Court's thinking. And in terms of the cases we're going to discuss here tonight, Professor Koh wrote an amicus brief in the Trump versus Hawaii case on behalf of former and current national security advisors and other people who advise on national security issues to the government, of which John Bellinger, another one of our panelists, was actually a client to that amicus brief because he was a former national security advisor. So, small world for you there.
Have to pay you, Harold.
Oh, you did. You did. He doesn't send him the check.
John Bellinger is a partner at Arnold & Porter, where he leads the public international law practice, but he also served as a legal advisor to the State Department from 2005 to 2009 under the second Bush administration, and a legal advisor to the National Security Council for the White House from 2001 to 2005. Both in his capacity in the State Department and in his private practice, he has participated in a number of Supreme Court cases, including some touching on some of the very issues we're going to speak about tonight, such as the Alien Torts Claim Act. Then we have Donald Trey Childress, we'll call him Trey, for Dean of Faculty at Pepperdine Law School. And we can now say that he is the incoming counselor to the legal advisor to the State Department, Jennifer Newstead. So he'll be moving to DC soon to take up that role and really will be at the front edge of the issues we see in the next term. And he previously practiced at Jones Day in DC in appellate litigation as well, so also very familiar with the way these issues are litigated. And finally, we have our practitioner, Jessica Ellsworth, who is a partner in the Supreme Court and appellate litigation practice at Hogan Lovells. Jess's practice means that she appears before appellate courts and the U.S. Supreme Court on a regular basis. In terms of the cases we're talking about tonight, she wrote the amicus brief on behalf of the Kingdom of Jordan in the Jesner versus Arab Bank case. So we're going to be very interested in hearing her take on that decision. And her firm was also counsel to Hawaii in the Trump versus Hawaii case. So I don't think we could have done any better in terms of the relevance of our panelists. And we'll start off by asking Professor Koh to give you a little bit of a background, some prominent features of the Trump versus Hawaii case, the elephant in the room. And then we'll open it up to some free flow discussion and then tackle the next case. So thank you all for being here.
So first, thank you for having me. Don't take this bit out of my time. Do we have any summer associates here? Oh my God. Okay, good. Good for you. I was first brought to the American Society by Peter Truboff, president of the society, and now a Manley Hudson winner. And I kept coming back. And so that was a long time ago, but I encourage you to do the same and to be on these panels in the future. As everybody knows, the Trump administration won a narrow 5-4 victory in the travel ban case. Let me say a word about how it happened, what it held, and what lies ahead. Obviously, a key vote was provided by Justice Gorsuch, but Justice Scalia would have voted the same way. The puzzling position was that taken by Justice Kennedy, who let's face it, didn't have a great term. We'll hear more about it in his opinion in Arab Bank, which attracted a majority for very few pieces. I think what probably happened, if you look closely at the opinion, is that Justices Breyer and Kagan thought that they could get Kennedy's vote on the notion that on remand it could be unconstitutional as applied. And so they wrote a fairly technical opinion about how the waiver system would work. Kennedy then sort of acknowledged it in his short opinion, but then ended up also saying, I join the court's opinion in full. So who cares what he said? And more than that, he makes this strange plea as almost his last plea on the court. Let's hope government officials obey the law. You know, an anxious world is looking at what's happening. You know, if you wanted to send that message, you should have struck down the travel ban. So it was not a fine performance by Justice Kennedy. It rang of him being tired. What did the court hold? The majority opinion, I think, will go down as really one of the great self-deceptions, particularly the line, Korematsu has nothing to do with this case. And if you believe that, I have a bridge near the Kremlin to sell you. Chief Justice Roberts says, with great fanfare, Korematsu was wrong the day it was decided and overruled in the court of history. And then he says, but this case has nothing to do with it. In fact, it had everything to do with it. Only by that feat of self-deception was he able to say that the travel ban ought to be upheld. And Justice Sotomayor, who has emerged this term as really a great voice on international law, I think she was right, in my view, just whacks him. Now, recall that in Korematsu, Justice Jackson's dissent had said that when you rationalize the Constitution to accept these kinds of outrageous practices, the opinion lies around like a loaded weapon. Donald Trump had said, everybody from Islam wants to hurt us. That's a quote. And then he said, this has been done before. FDR did it against the Japanese. So he actually seized the loaded weapon that Justice Jackson mentioned. And nevertheless, Chief Justice Roberts says Korematsu has nothing to do with this case. What was the core of it? It's the difference between group discrimination based on a presumption which grows out of who you are, as opposed to judging people by the content of their character as individuals. You know, I've reviewed many terrorist applications. You do it based on who they are and what they've done, not based on these kinds of outrageous group stereotypes. And that was the core of the opinion. Now, what the government said, and Roberts bought it, is that, well, maybe travel ban 1.0 was driven by a statement like, we're going to have a complete and total Muslim ban. But by 3.0, it's become a facially neutral policy. In fact, the original sin of the original group template was never dispelled. And no less than Justice Thomas had once said, if a policy remains in force without adequate justification and despite tainted roots, it appears clear enough to presume conclusively that the government has failed to disprove discriminatory intent. Now, it was also an opinion that was wrong as a matter of fact and law. Chief Justice Roberts said, there's persuasive evidence that it has a legitimate grounding in national security concerns. We filed a brief, my client John Bellinger, and 51 others, bipartisan national security officials, who were in the government up until 6 days before the travel ban was initiated and into the Trump administration, the US government never in 15 months of litigation offered a single affidavit attesting to the national security threat. And by the way, these are not so hard to generate if you want to generate them. In fact, their own actions were so dilatory that their claim that there was some kind of urgency never was verified. As a matter of law, statutory interpretation, they read the key statute. Justice Roberts says the statute exudes deference to the president in every clause. That description better describes his opinion. He never explained why a law that barred nationality discrimination in immigrant visas didn't subsequently modify the law in question. And on the constitutional claim, the religious discrimination claim, remember that in the Masterpiece Cake case, they found that state officials' expression of hostility to religion meant that a baker had a religious discrimination claim. And then a couple of weeks later, they ignored dozens of overt anti-Muslim statements by all of the people who implemented this. Finally, the most egregious legal error was the absurd standard of review. Ryan Goodman and others in the Just Security blog described it this way: even if we know that an immigration policy was motivated by blatant official animus against religion, the policy should be sustained so long as the government can proffer some national security basis for it that might be deemed rational. That should not be the standard. Now, why is this a problem? Because, as Justice Sotomayor pointed out in dissent, this administration has lots of national security claims, right? Canada, they say, is a national security threat. They're ready to bomb against Assad's chemical weapons because of the national security threat, although they won't admit Syrians into the country. They'll separate infants from their parents at the border in the name of national security. They'll expel transgendered people from the military claiming national security. They'll impose steel and aluminum tariffs based on national security. And now they're contemplating, and this is according to leaked memos from the Department of Energy, using the Defense Production Act and the Federal Power Act to require grid operators to buy from failing coal companies as a stop-loss matter in the name of national security. Now, they are going to seek judicial validation from the courts. But remember that not every case gets to the Supreme Court, and it doesn't get there quickly. The three reasons why the travel ban case is not over is, number one, it's based on statutory grounds. If Congress changes hand, or even the House of Congress, they can start to legislate a change in that statute. Secondly, there are all kinds of steps that can be taken in terms of transnational litigation, particularly in European Court of Human Rights countries. None of the airlines that fly into from those countries transit directly to the United States, which means that a lot of countries have to help and support. They are bound by religious discrimination norms in the ICCPR and the European Convention on Human Rights, and you can expect there to be litigation. You can also expect private entities to make various kinds of adjustments. Already universities are conducting entire programs online for students who are being barred. You have technical workarounds being done by Silicon Valley companies, et cetera. And then finally, the case is not over, because all that the travel ban litigation said was the ban is not unconstitutional on its face so that they would uphold the preliminary injunction. But they essentially found standing, and then it was justiciable. So it'll go back to the trial court where you can put in evidence as to whether the waiver system is or is not being fairly administered. And if you look very carefully at Kennedy's opinion, this is what he's really talking about. This is what they tried to get him with. If they produce evidence of discriminatory action and intent, you can get a permanent injunction against the way the travel ban is actually being implemented. So I think it will continue to be litigated on many fronts. And it will be up to the lower courts, I think, to implement this. A final point is, when we talk about cases for next year at the Supreme Court, the obvious case will be the family separation cases, which are working their way up. And notice what's happened there. The Trump administration abandoned the old policy in favor of what they called zero tolerance. But under the Flores case, you can't separate parents from their children and hold the children for more than 20 days. So when that was struck down, they were forced to reunite the parents and children, even though thousands of children had been stripped away from their parents. And then they couldn't reunite them in time because they didn't know where they were. And that's where we are now. So we have multiple litigations going on now. What Trump has said in regard to all of this is a catch and release program. Another word for the catch and release program is it is not necessarily a crime to cross a border if you are a refugee. You have rights under asylum law, which can only be adjudicated once you're here. So the quote, catch and release is actually describing a set of rights under international law that are bestowed on some of the people who are crossing the border. Anyway, they're now reunited. They're outside of jails. They're wearing ankle monitors. That basically looks like the policy we had before, except that thousands of families have been subjected to untold human misery for absolutely no reason other than to have a talking point. Now, let me point this out. Let's not kid ourselves. If Justice Kavanaugh is confirmed, he will move further in this direction. He is further to the right on these issues than Justice Kennedy. Let's stipulate he was my student. He's a nice guy. That and being qualified to be on the Supreme Court is what should get him confirmed. After all, Merrick Garland is much more qualified than Kavanaugh, and he didn't even get a hearing. So we can talk more about this. You will notice that when Kavanaugh praised Trump for the most extensive process ever, hard to know factually how that was determined, and then said the judiciary is our crown jewel, which of course is not what Trump has ever said. He concluded by saying, and to the American rule of law. The American rule of law. And for anyone who sits with the American Society of International Law, that should have made your hair stand on your head. Because a lot of what this society has been devoted to is the notion that the rule of law is not a wholly American construct. So let me stop there. I've said enough on this point, but we'll see how things turn out from here. Thank you.
Thank you so much, Professor Ko. So I think we know where Professor Ko stands on this case. And while I won't ask anyone to actually play devil's advocate, I'd love to hear from a few of the other panelists as to their views. Did the court get any of this right? What's sort of going on and motivating the decision? What would you like to add?
As Harold's client, why don't I take a stab at just a couple of things. A client probably should always let his lawyer speak for him, but I'll add a couple things. So one, Harold did a terrific brief on behalf of more than 50 national security officials when we basically said we thought the travel ban was completely unnecessary, that it not only was not necessitated by national security, but that in fact would be a danger to our national security. And I truly believe that to this day. I don't think it is making us more safe. I think it is making us less safe by generating hostility around the world, not only with our allies, but also in the Islamic world. And I thought Hal did a terrific brief. I actually wrote my own brief on behalf of a number of conservatives in which we, led by Evan McMullen and Max Boot and a number of others, because there really was just sort of bipartisan concern about the travel ban. And this group of scholars in the brief that we wrote and opinion leaders said, the United States does not discriminate on the basis of nationality. We haven't historically, but we have rejected that in recent years, particularly in immigration. And so we took, as you know, in the travel ban, there were sort of two principal arguments. There was a constitutional argument that it violated the First Amendment by discriminating on the basis of religion, which it seemed to be pretty clear that it did, and the president even said that he was discriminating on the basis of religion. We decided, though, that we wanted to take the statutory argument, and we said that the president also violated the Immigration and Nationality Act not only by essentially going beyond the powers that Congress had delegated to him by setting up his own structure, but specifically violating the immigration, the nationality discrimination provision that had been added by Congress about 40, 50 years ago, in which there had been bipartisan support, really largely led by Republicans, who had rejected the idea that we discriminate on the basis of nationality in our immigration decisions. And that so we had conservatives saying, this is who we are as a people. We decide on the basis of merit and specific threats, not on the basis of large nationality bans. Unfortunately, that was rejected. Some of you may have heard me say in NPR, I think the issue here was, we were on travel ban 3.0, it was redone 3 times, and you had the very best lawyers in the United States, of which there are many in the US government, rewriting the travel ban to withstand both statutory and constitutional muster. And so the final version, as I said to NPR, was still a pig, but they had put so much lipstick on it that that it was beautiful enough for 5 members of the Supreme Court. And so I think that really is what happened here. The first version was just awful. The second version was still pretty bad. And the third version, they had sort of prettied it up enough that, Justice Kennedy, kind of holding his nose, could kiss it. So that was, I think, why I don't think probably either Harold or I were surprised that it was ultimately upheld, but it was unfortunate.
So I'll just add a couple other points, and as Jennifer said, we litigated this on behalf of Hawaii, so you can imagine where my view of the case begins and ends. The couple points that I would just add to what was already stated are, I think there's an open question that remains on whether there are actually any limits that the court would enforce on Section 1182F. Is there something that the executive could do that this court would say goes too far, or is there not? And what is that limit? So that's something that I think remains somewhat of an open question that we may hope we never are in a position of trying to answer it, but is something that I think remains to play out. The second thing I note, and this echoes what John said, is that by the time the third travel ban was being litigated, it was a harder case because there were more people from the executive appearing to buy into it, and that, I think, gave the court the cover it needed to be able to view this through a national security lens much more so than either of the first 2 versions. We all recognize that when the court acted on the stay motion before the case was even briefed, that there was just, it was going to be a much harder case on the third go-round. Query what would have happened if they had gotten to argument on the second version, if they had not pushed it off until October and had been able to hear it before the third version came up. And then the third thing that I'd note that I think is maybe relevant to this group is there was this notion evoked that it is a fundamental act of sovereignty at international law to have this right to exclude. And that's not something that has come up in precedent recently. And it is sort of this notion of a fundamental right that I think remains to be developed, and given things happening globally everywhere, what this fundamental right to exclude is and how international law plays a role in that, I think is something we should all be keenly attuned to.
Well, I think I should begin by saying that since I've been in the legal advisor's office for all of 8 hours, that everything that I say is in my personal or academic capacity and doesn't represent the views of the office. With that out there, I think one thing that's remarkable about the briefing and the opinion is how united many from the left and the right, from conservative and liberal circles, from previous administrations, as the briefs that you all filed made plain, were that that the travel ban shouldn't survive because of what had happened in the previous iterations. And I think that all then takes us back to Justice Kennedy. And the question is whether or not his concurrence was an act of frustration or was an act of wisdom. The narrative, of course, coming to the end of the term was that it was an act of frustration. It was of a man throwing up his hands because he was done. He had done his service, and he was leaving it to the democratic and other processes to find his successor. And he wasn't quite dropping the mic, but he was kind of dropping the mic. Unless he had had it in his head at the time of the argument that he was going to retire, though, he showed substantial skepticism in the argument itself. Which makes one wonder whether or not it was an act of frustration brought about at the end of the term, or whether there was some wisdom in his decision. And perhaps maybe the wisdom was that, as Harold said, it goes back to the lower courts. Now, that may not be the most efficient. It may not be the best for the view of international law, or indeed domestic law or immigration law in the United States. But one wonders if there is some saving grace in putting the litigants through their paces to make them show more concretely what exactly is happening on the ground. And I think that if that is the case, then Kennedy has found a way to sort of masterfully reserve or continue to embolden certain powers that the president at least has alleged that he or she at some point has inherently, as opposed to challenging indeed the person who is this president. I mean, one of the other things that's striking about the opinion is that the majority opinion refers to the president as the president, and the dissent frequently refers to him as Donald Trump. And that fits into sort of a certain narrative that we've seen in the country of legitimacy and illegitimacy. And I think perhaps maybe part of what Kennedy and maybe at the end of the day Roberts were doing was looking past the person and looking at the office. And whether or not that was wise in the individual, in this case, I think we're going to have to wait and see. But my observation would be, I wonder if at the end of the day this wasn't frustration, but perhaps a wise way of preserving some power that some justices at least saw in the office of the president.
Trey, between an act of wisdom and an act of frustration, I'd call it an act of surrender. Surrendering the role that Kennedy has in fact played in many other settings. The central contradiction of this case was that Donald Trump both called for extreme vetting and called for a group ban on all Muslims. Those are not the same thing. What we have is extreme individualized vetting. What you're describing as like the wise consideration of people on the ground is like saying, let's send it back to the district courts to figure out how many of the Japanese people who are being interned at Manzanar are actually disloyal to the United States. We ought to know enough at this stage to be able to enjoin it. But I think as has been put well, the fact that this came up on a stay motion meant that the court decide the issue on the stay, and then the justices who voted for the stay were essentially complicit in what was going on. So they weren't going to strike it down 6 or 7 months later. Where we needed more facts was on the front end. I mean, compare this with the LGBT cases and same-sex marriage cases in which Kennedy actually saw these people as real human beings. There, the plaintiffs got into the press and in the media the stories of the couples who would be affected by the marriage ban. How many people here can actually name a person who is affected by the travel ban? That was a failure of public relations. It should have been those 10 people and the students and all the other people who are being injured by the travel ban standing in front of the Supreme Court saying, this is about me, this is about my mother, as the same thing happened with the same-sex marriage cases. That's the kind of thing that influences Anthony Kennedy at the end of the day. You know, he's not a great principled legal theorist, as we know, but he is affected by human suffering. And I think what ended up happening was both the posture and the way it was litigated did not allow those cases to be made. But I think Justice Kennedy, in other circumstances where he has proclivities, is willing to take that step. On this one, it was for a bunch of faceless people who were outside the country, and he was leaving, and he wrote the opinion that he wrote, which I don't think, it's certainly not an act of wisdom. I mean, if you're going to call for that, then withhold your vote, Bakke style. and make sure that they follow it as opposed to joining the majority opinion. Who's going to read Kennedy's opinion now? He joined the majority opinion in full. And, act of frustration. Frustration with who? It's an act of surrender. And that's what it should be remembered for. It was not his finest hour.
I think, does the audience have any questions on this? I think we should maybe move along to something that's much less of a political lightning rod outside of the confines of this room at least, but it's something that I think has been interesting to international practitioners for at least a decade and a half now. And that's the Alien Tort Statute. So I'm going to turn it over to Jessica, and the question on everyone's mind after Jesner is this the last time we're going to talk about it in this room? So, Jessica?
No.
It's a fair question. Let me start by just setting the scene a little bit for this case, because I think it was something that was much less a part of our news cycle and something that everyone knows all the background on. This case involves 6,000 plaintiffs from outside the United States suing Arab Bank, a Jordanian headquartered global bank that does have a New York branch, alleging that Arab Bank was complicit in and facilitated terrorism acts that occurred in the Middle East over a decade. And the plaintiffs brought this claim under the Alien Tort Statute. The Supreme Court, as everyone in this room probably knows, has been narrowing the reach of the Alien Tort Statute as the Human Rights Bar has been seeking to expand it. And the two cases that came before this one in the Supreme Court, Sosa and Kiobel, both resulted in pretty significant narrowing of the availability of the Alien Tort Statute through the conclusion that it is not actually a cause of action. It's a jurisdictional statute, so you need to have a cause of action, which in 1789, when the statute came into being, was really limited to claims about piracy and injuries to ambassadors on foreign ambassadors on U.S. soil, or you need to have an argument for creating a cause of action as a matter of federal common law. And this court has been very cautious, and you'll see this come up in the decisions about the notion of creating new common law causes of action. Then you have Kiobel, which says where the relevant conduct all took place outside of the United States, there's going to be no extraterritorial application of the Alien Tort Statute, which might have resolved this case. And in the Second Circuit, there was a big argument that this case could be resolved based on Kiobel, on the extraterritoriality, because all of the relevant conduct, with one exception, took place outside of the United States. The one exception is that these banking transfers were routed through the New York branch, all electronically, no physical involvement, no personal involvement by anyone, but they were US dollar denominated transactions. So they did, as I always thought of it, there was a ping where they bounced off of the New York branch in the process of being processed. So the question was whether foreign corporations could be defendants under the Alien Tort Statute. And the Second Circuit had said no. There was a raging debate in the briefs as it went to the court about whether customary international law has a norm of corporate liability. And the parties really disputed this. At the end of the day, that really was only one justice definitively took a stand on that, and the others really took a pass by concluding, as Justice, it was a 5-4 decision, authored by Justice Kennedy in significant part, although not joined in all aspects of his opinion, concluding that foreign corporations are not proper defendants under the ATS. And the main reasoning was that the goal of the ATS was to minimize foreign entanglements that the U.S. found itself in, and that in this situation, allowing foreign corporations to become defendants was in fact increasing the foreign tensions. And in part, the court looked in a number of different places to the amicus brief that was submitted by Jordan, talking about the tension that this case has caused in the U.S.-Jordanian relations over the past 13 years that it has been pending. So that brief, I think, did play a role in the way that the court was thinking about whether the Alien Tort Statute's goals are properly served with foreign corporate defendants. As I said, only one justice really latched on to this notion about whether customary international law allows for corporate liability or there's a norm of corporate liability, and that was Justice Alito in his concurrence, who concluded that customary international law does not generally include corporate liability. Justice Kennedy essentially punted on it and said there were very good arguments on both sides, so he would look to see what he thought Congress intended by looking to a similar statute, the Torture Victim Protections Act, which does not include, it's specifically addressed only to individuals, and said for him that settled the matter. This should only be something that was applied to individuals. Now, query whether that line of reasoning means there is any different result for a domestic corporation versus a foreign corporation, but on its face, the case is only about foreign corporations. Justice Gorsuch, the new addition to the court, took the position that back in 1789, there would have been no corporate liability under his original reading of this particular constitutional clause. Under his reading of the 1789 statute. And so he concluded that there should not be corporate liability now, and he also doesn't like creating new federal common law causes of action. The dissent, which was written by Justice Sotomayor, could not have disagreed more on basically every aspect of the decision, from the purpose of the act to what the history showed, what the text showed. Everything for her pointed in the direction that there should be corporate liability available under the ATS. So I think the open questions that remain, and I'm curious to know what everyone else thinks, are whether there is a similar whether there's any way to reach a different conclusion for domestic corporations, and then what happens when you have foreign individuals who are defendants as opposed to foreign corporations. So those are the things that I think remain to be decided.
Go ahead, John.
Yep. I'd take a stab at this one too. So I've been dealing with ATS cases for almost 20 years, mostly starting when I was legal advisor, because although the human rights community likes to bring them, and I can understand why, foreign countries hate them because they're often challenging the actions of foreign companies and almost always challenging the actions of foreign countries and their governments and their officials inside their own territory. So, I had a long parade of officials during all my time as legal advisor coming and saying, we're all in favor of international law, we're all in favor of human rights, but this idea of having U.S. judges deciding a case involving a foreign plaintiff against a foreign company involving a foreign government in a foreign territory and letting a U.S. judge decide who's right or wrong, we think is a violation of international law. I actually, in an earlier brief in Kiobel, had put together a long list of all the diplomatic notes of the ones that were actually publicly available, and there are a whole lot more that are not publicly available, of all of the countries that could complain about the Alien Tort Statute. I'll just make a couple of comments. Harold already alluded to this, and the decision is a mess. I mean, it's really, Kennedy's decision is just sort of all over the map. I am, hopefully one day we'll find out the answer to this. I am convinced, and would put some money on it, that until about a week before it came out, the decision was that there was no corporate liability, not that there was no foreign corporate liability. That was actually the decision that went up from the Second Circuit, can corporations be held liable under international law? That Kennedy's decision makes no sense. It just makes no sense to be limited to foreign corporations, other than that it's a narrower opinion and you leave some things open. But every word that he says in the majority opinion, if you take out the word foreign, all makes the same point. So I'm convinced that it was no corporate liability, and someone managed to convince him, let's just sort of keep this a little bit narrower. All on the history of corporations under international law and deference to foreign nations and reduction of friction and comedy. So what does this mean, though, is that cases against U.S. companies remain open, and that the court has been saying from Sosa to Kiobel and now to this one is that we are leaving the door ajar, and it's now someone WAG said, not me, after Kiobel, that they had they closed the door but left it unlocked. So I'm not sure, now it's closed but unlocked, but they've left the key. And so there are a number of ATS cases currently pending that are essentially unaffected by this decision. There's a Cisco case out in the Ninth Circuit. There's an ExxonMobil case here in D.C. There's the famous Doe v. Nestle case, which has been going on forever and ever out in the Ninth Circuit. I think the Kaki case has been resurrected in the Fourth Circuit. So all of these cases, because the Jesner didn't say anything about corporate liability, and they punted yet again on that question, remain alive. Another thing they punted on, I did a Lawfare post on this and begged them to resolve if they were going to take another ATS case, resolve the circuit split on what the heck does touch and concern mean. And as many of you follow this area, there is a circuit split on how do we interpret what it means to touch and concern the territory of the United States with sufficient force to overcome the presumption against extraterritoriality. And there's a split on that. And they could have easily, if they were going to go to all of this work over 9 months, have said something about that. So that remains unresolved. So a lot remains unresolved on, can U.S. corporations be subject to, presumably, yes. What does touch and concern mean? And then finally, and I'll get to this a little bit more, one thing that was interesting aside was that the Trump administration did not actually change the position of the Obama administration, begun under Harold, and so that in its amicus brief, somewhat surprisingly to me, it did say, yes, there is corporate liability, but that the case should be tossed on the ground that it actually didn't touch and concern the United States with sufficient force, that just those connections involving Arab Bank were not enough under Kiobel. So one might have expected, and I think this actually largely shows both the influence of sort of precedent, but also probably influence of a couple of the really good lawyers, career lawyers in the SG's office. The Trump administration said, there is corporate liability under international law, and of course the Supreme Court sort of partly ignored that, at least when it comes to foreign corporations. So anyway, once again, a lot left open under Jesner.
Well, I agree with most of what John said. Kennedy's opinion here is an opinion for 5 justices with regard to the facts, Part 2B1 and 2C. So I think it's going to be quickly overtaken by some real opinion. Number 2, Alito and Gorsuch, who provided the key votes, basically said they wouldn't have voted for Sosa. That's their difference. Sosa was 6-3. So it's a change in the court's personnel. If it moves further, again, it will be because of a change in the court's personnel. Justice Kennedy, who joined Sosa, changed his view without actually clarifying on what basis he was doing. He likes Filartiga, which is why they preserve foreign individuals, because you can't overrule it, an F-cubed case, as they call it, and preserve Filartiga. And he understood that Filartiga was important. And in Kiobel, where I signed the first brief of the U.S. government, but not the second brief, when the Second Circuit came up with the notion that corporations couldn't commit human rights violations, that was laughable. You mean to say that a pirate commits a human rights violation, but Pirate Incorporated doesn't? Or let's say this, Nazi commits human rights violation a la Filartiga or Peña-Urala, but not Nazi Incorporated. Give me a break. And when it became clear to them that they couldn't take that position without looking like they were extending Citizens United to use Kogan's violations, they started coming up with the touch and concern test. And it was another classic in Kiobel, which is that Justice Kennedy has a sort of incomprehensible concurring opinion, but concurs in the opinion of the court which throws in touch and concern as a way to kind of alleviate this. In the age of the internet, what on earth does touch and concern mean? It's hard to imagine a worse test to apply, which of course has not been elaborated and, as John said, leads to chaos. And finally, Jessica, I'm sorry, but the United States State Department brief did not credit the kinds of disruptions in the same way as the amicus brief paid for by the governments. And frankly, a lot of this has to be filtered through whether the State Department thinks there are genuine disruptions or not. And we could have a great system where every government who feels aggrieved because its company gets sued comes in and starts claiming that there's disruption to US foreign policy that makes it non-justiciable. But that ought to be determined at least through the filter of a US government amicus brief, and that's not what happened here. Anyway, I think that when you go back and dissect it all, a lot of this turns on the evolution of Justice Kennedy from being supportive in Sosa to finally wanting to limit his support to Filartiga only. And then I think John is right. It was too much for him so by the way, in many ways, it's crazy to draw the line on foreign corporations, because all it does is encourages activity of US corporations to be shifted to foreign corporations to escape the liability. And a final point, which is the notion that international criminal tribunals don't permit this somehow means there's a norm of international law. As everybody knows, the ICC Rome Statute is based on the notion of complementarity, which means that domestic remedies are provided by domestic law. And such a remedy is the Alien Tort Claims Act. So I think that as Justice Kennedy on this is run out of principles and he's not going to be there anymore. I'm not sure that this is moving in a clarifying direction, but I think we shouldn't kid ourselves that this opinion or this outcome is going to last very long. They're going to have to relitigate this in some setting. And the plaintiff's bar is going to have to think hard about what kind of case they really want to get up there on this issue. If it's with a US corporation whose practices are so clearly aiding and abetting gross violations, and they can get past various kinds of obstacles in either the Second or the Ninth Circuit, they could well win, and then Filartiga would be extended to some kinds of US corporate activity.
Well, it appears Justice Kennedy's doing pretty well today. And maybe that's the answer to the question that I was going to pose, because I had a question and an observation. And the question was, why has the ATS always been such a mess? There are lots of other areas of law that are a mess, but this one has been particularly messy. And maybe Harold answered that by saying that Justice Kennedy has sort of shifted around. But one wonders with the change on the court if it will cease to be a mess. And the second, more to my heart in academia, is the fact that Gorsuch took so much time to basically rewrite Belia and Clark's article on the Alien Tort Statute, and didn't really get anyone to sort of join him in this exercise in originalism to shut down the whole project, because the ATS, in the view of Belia and Clark, and I also think Tom Lee in a Chicago article, is one of really related to diversity jurisdiction. And it was an interesting sort of call in the wilderness, if you will, because Alito's concurrences in Chiobel and talk of touch and concern, I think, was largely designed to drive lower courts to adopt his very narrow view of the circumstances under which the Alien Tort Statute could be applied. I can't really imagine any district courts adopting Gorsuch's view, because those arguments have been out there for years and have been offered up, and no one has sort of taken up the opportunity. I guess there's always a first. But I would, if there are any observations on why the ATS is such a mess and what Gorsuch was getting at, I'd be interested to hear them.
Justice Gorsuch, in his first year, proved that he cannot attract a majority of the court for most of the propositions that he writes about. They've been over this stuff, and Clark and Belia and those things are out there, and they didn't go for it before, and those people aren't going to change their mind because Justice Gorsuch is on the court. Justice Gorsuch got into the habit in the lower courts of writing a lot of solo opinions to kind of attract attention, but he's on the court now. And it's palpable that the other justices don't listen to him very much at this point, as has been reported. And I think he's going to have to look hard into his soul as to how he wants to be influential on these issues going forward. And he demonstrably lost his majority opinion in a couple of cases. And it's because the justices, even the ones who are ideologically simpatico, aren't thrilled by how he's doing there. So I think that it's not the ATS that's a mess. I mean, by the way, the words of the ATS have not changed since 1789. And in Sosa, we had a 6-3 as to what it meant. And so maybe a good question for Judge Kavanaugh is, do you believe that stare decisis matters with regard to statutory interpretation, particularly when the facts haven't changed? Maybe you have greater sway to reconsider in constitutional cases, but even there in Casey, they've called for stare decisis. But Alito and Gorsuch should say, we're bound by Sosa. That's not what they said. That's activism.
Yes, one question.
Hi, my name is Mark Feldman, and I was there at the creation.
1789. You're well preserved, Mark.
That's a proper comment. I sometimes feel that way, and so do my students. Anyway, Philartica. I was the only one in the legal advisor's office at the time who had a concern about the Carter administration's position supporting jurisdiction in Philartica. And it wasn't because I don't care about human rights. It's because, like all State Department lawyers, I'm worried about universal jurisdiction, reciprocity, extraterritorial application of law, and wondered where this was going to go. We now see where it went. But I will say, and I'll limit my comment to this one observation, one of the fundamental problems about the Supreme Court is they never, until this decision, focused on the original congressional intent, which was the concern of John Jay and colleagues that the failure of states to police violations of international law or to provide a remedy, including violations of treaties or of citizens who might violate the neutrality of foreign countries, for example, in Florida at that time and further west, not to mention Canada. That was, in my opinion, and I've spent a lot of time with this, the concern of the framers, which was, I mean, if you read the Federalist Papers, why do we have federal courts, and it was to get some kind of uniformity, federal control over conduct by state governments or individuals that would cause problems that could lead to war, for example. And I think, frankly, and if you look at the neutrality controversy of 1793, I think I have some evidence that it was neutrality that they were most concerned about, and that's pretty hard to wrap your mind around when you're thinking about the present world. This is an exercise in what is originalism. Assuming you subscribed to the original intent, the reinvention of it by the I don't know, the beginning of the Reagan administration or just in the Bush administrations, to say that Congress, that international law was not part of the law of the United States unless Congress enacted it. That's how we got confused here about, in my opinion, about what the framers had in mind. They understood that there was a body of law out there that was called international law that could be enforced. John Jay, they thought it could be done without a statute at all. John Jay's charge to the jury. We've lost that, Now Gorsuch and others are going back to it. So Scalia, by the way, did not, he dissented in SOSA despite being the father of originalism, because he said, you know, we've had positive resolution. We're positivists now. We're not natural lawyers anymore, and we have Erie. And if you want to know what Judge Kavanaugh, all you have to do is read his extended remarks in Bahani. And he'll tell you where international law doesn't exist unless Congress enacts it as such.
Thank you very much. So let's move on to a third case. This is the animal science case, or also known as the vitamin C case. And Trey will tell us about this case. And I was speaking with Chuck this week about the panel, and we both said that this case, which I think came down at the end of April, has already affected our practice. I mean, we're already having to write about and grapple with the effect of this decision. And Chuck and I both practice, you know, international matters in litigation, and so this is coming up in our practice, and I think that to that end, it's going to be really important for lawyers around the world to understand it. So,
thanks for that introduction, because I was thankful that I got the most provocative and newsworthy opinion of the entire Supreme Court year, and that's the question: what level of deference is due to the submission of a foreign sovereign when they tell a U.S. court what their own law is? The case is interesting. It comes in a procedural posture where various purchasers in the United States of vitamin C seek to sue several Chinese companies, alleging that they're part of a cartel and that they're fixing prices in the sale of vitamin C into the United States. The defendants, in a motion to dismiss, say, well, we might be agreeing on the same price, but that's because we have to. And that's because a ministry in China tells us that we have to set a certain volume when it comes to export, and also have to set a certain price. So they're raising sort of a foreign sovereign compulsion defense. They could also be arguably raising a Hartford Fire sort of true conflict, international comity abstention defense. The district court looks at it and says, I'm not sure I really believe you. And what the defendants get is somewhat remarkable. They actually get a statement from the ministry. And according to the Second Circuit, it's the first time that the ministry has ever filed an amicus brief in a U.S. court proceeding. And the Chinese ministry says, yes, right? We've told them they have to limit the volume of vitamin C, and we've also told them to set the price. And they're not doing anything unlawful as a matter of Chinese law. In fact, they're complying with Chinese law, and therefore we encourage the U.S. court to dismiss the case. And the district court gives consideration to that, but says not so fast, because there's a bunch of other information that is put in the record. There's an expert affidavit which points out that that's actually not been the consistent position of the Chinese government. There is expert information regarding submissions that China has made to the WTO and other public statements on the part of the Chinese government, which sort of seem to say, well, we actually haven't told them to fix prices. We may have recommended it, we may have recommended volumes, but we've never actually affirmatively told them that they had to do it. Or if we did, that stopped at some point in time, and it stopped at a point in time after the suit. So the district court rejects the motion to dismiss. The case goes forward. It's eventually tried to a jury. The jury itself in the case also hears this question of whether or not the jury thinks that the defendants were required to comply with these volume and price caps, and the jury rejects that and returns a verdict of, I think, $147 million or something to that effect. So it goes upon appeal to the Second Circuit, and the Second Circuit says, District Court, you get it all wrong. The Second Circuit says that United States courts are, quote, bound to defer to submissions of foreign sovereigns when reasonable. Okay, so there's a pretty firm rule, bound to defer, and then there's this sort of rule when reasonable. But the reasonableness determination is going to be determined in the Second Circuit based simply by looking at the materials submitted by the foreign government, and not any of the materials submitted counter to that, such as expert declarations or affidavits. So it is a very deferential rule when it comes to the submission of foreign sovereigns. The United States Supreme Court takes this case in hopes of clarifying a split regarding what deference is due under Rule 44.1 of the Federal Rules of Civil Procedure. They make some preliminary points in a unanimous opinion authored by Justice Ginsburg about the history of Rule 44.1 and the fact that determinations of law are no longer factual determinations to be made by a jury, there are legal determinations to be made by a judge, which means that the judge can look at submissions of the parties as well as any outside material in the same way that a judge looks at domestic law in determining what the law is. And also they make the point that on appellate review, the standard of review would be de novo. What the Supreme Court gives us, besides a tour of the history of Rule 44.1, is a sort of smackdown, if you will, of the Second Circuit's bound to defer language. And the question is, do they give us something much better? What they tell us is that U.S. courts have to give respectful consideration, not bound to defer when reasonable, but respectful consideration to submissions offered by foreign sovereigns in U.S. courts. And they tell us that no single formula or rule will fit all cases, but relevant considerations include the statement's clarity, thoroughness, and support, its context and purpose, the transparency of the foreign legal system, the role and authority of the entity or official offering the statement, and the statement's consistency with the foreign government's past positions. So on the one hand, we might say, it's great that the court has clarified this rule, that we're not absolutely bound to defer. And as a sidebar, courts aren't absolutely bound to defer to submissions of the United States government. I mean, one of the points that Ginsburg makes, indeed, go back to the Alien Tort Statute case where the United States government, basically says that there can, in certain circumstances, be corporate liability. And this court rejects that view, right? And they give respectful consideration, but they're not bound to defer. So on the one hand, they're sort of strengthening and tightening up the connection, or at least the analogy between the interpretation of foreign law when submitted by foreign sovereigns and U.S. law when submitted by the United States government. But I think one has to ask whether or not this sort of multi-factor, non-conclusive, varying with the circumstances of the case test does enough or gives the appropriate guidance to lower courts. And so I think when you look at this case, there's the narrow issue, which the court resolved, which is what is the level of deference required, and it's sort of respectful consideration instead of bound to defer. And then there are these sort of larger issues. One wonders whether this rule giving discretion to the district courts will sort of work some mischief. I'm not sure that it will, but there have been some recent filings and recent cases, both in the area of choice of law or conflict of laws, where litigants have tried to use this rule, not in the case where a foreign sovereign has actually made a submission on the foreign sovereign's own law, but in cases where the litigants have made submissions on the mets and bounds of a foreign law, to say, look, the court can do whatever it wants, right? It doesn't have to look just to the experts. It doesn't have to look just to the submission of the parties. It can do whatever it wants to do. Now, courts traditionally have been able to do that, but litigants are trying to arm them with a little more vigorous tool in which to investigate or interrogate foreign law. That's one. And then there was a case of I think 10 days ago in the Second Circuit, which involved issues under the Foreign Sovereign Immunities Act and submissions by the government of Argentina as to what Argentina viewed its law to require when it expropriated a company and refused to give a tender offer. And the Second Circuit said, look, we don't have to defer. Right? The Argentine government reads their law this way. Well, we don't necessarily read it that way. In fact, there's a great part of the Second Circuit opinion where they take the statute and they say it's not a model of clarity, so what we're going to do is paraphrase it and rewrite it. And so they include language from the statute, then parentheses, well, what they really mean is this. And the judges in the Second Circuit may be getting it right, but one wonders if this does raise sort of interesting concerns of international comity. And then finally, I think there are just some practical issues involved, and that is whether or not this will encourage or discourage foreign governments to file amicus briefs in cases, antitrust or other cases, that raise important issues of the interpretation of foreign law, whether these representations will be made or channeled through the State Department, and whether or not the United States government will make arguments based on their view. I mean, for instance, in this case, in the In re Vitamin C case, had the United States government come in and said, we agree with China, right? Would that have tipped the scale a little more? Again, not bound to defer, but with respectful consideration, notwithstanding the fact that the judge on the district court thought that there had been a change in litigating position. Would that have been enough to sort of tip the scale? And so one wonders, with this scale, if it's the right amount of discretion when it comes to district courts, or if it's too much discretion, and what this will mean in terms of the way practically that lawyers litigate cases, choice of law cases, and also cases involving foreign sovereign acts, either through the antitrust laws or Foreign Sovereign Immunities Act. And also one wonders whether or not this will encourage or discourage filings in the United States, either by foreign governments or the United States government in support of positions. And so besides that, I'll note that it was a unanimous decision. There were no concurrences. Justice Kennedy didn't say anything wise or frustrating. And Justice Ginsburg has yet another perfectly clear opinion when it comes to interpreting the Federal Rules of Civil Procedure.
And Trey, I'm going to turn it over to Harold in a moment, but one thing that I thought was interesting is that China actually did ask the Obama administration to weigh in at the Second Circuit level in favor, in support of their position, refused to do so. And then the court asked the Solicitor General's office to weigh in on the cert petition level, and the Trump administration sort of used it as an opportunity to go, against China's interests and put in a decision the other way. So interesting background there in terms of the relationships and the court taking, the administration taking a side one way or the other.
When I was clicking for Justice Blackmun, he said to me once, beware a unanimous opinion that comes down at the end of the term. They're the worst because they're not that carefully written and they're not that closely read. This is a pretty good example. So the people who are celebrating on this one was the American Society of Comparative Law because they're all going to make a lot of money now doing affidavits about competing interpretations of foreign law. What was left unclear is, does this also extend to us? Because it's not clear whether they're talking about international law and opinions of international law. You all remember, Garcia Mir versus Meese, where Lou Henkin gave expert testimony on the content of the norm of arbitrary detention. So you might see someone try to bring that in again. I think the problem, though, is Justice Ginsburg, on the one hand, says there's no formula or rule. And then she says, in the first part of the opinion, respectful consideration. Well, that's a formula or a rule. The only problem is we don't know what it means. It's actually kind of like we want to work toward denuclearization, which for Kim Jong-un means build more nukes, where for John Bolton it means complete, verifiable, irreversible denuclearization. And, they haven't clarified what that means. And the real problem is that respectful consideration in the context of Breard and Sanchez-Llamas means not much deference. In the context of a state AG, which is where they bring it up, it means some deference. But here it's in the context of deference to what a foreign government is saying what the law is. And there I think they should have called them out. If the Chinese want deference, order them to do it, claim foreign sovereign compulsion, and get active state. And don't hide behind this kind of legal opinion. And that's what they didn't do. They should have called them out on it, and they didn't do that. But I do think that that's where it's going to lead. Since Justice Ginsburg took them in this direction, the Chinese government can't just get away with opining about its own law and getting blind deference as they were getting from the Second Circuit. So now we're going to see the next round of cases be about foreign sovereign compulsion, which has never been decided by the Supreme Court, but was briefed in Matsushita and a bunch of other cases.
I have a very brief comment, although a longer shout out for Trey, actually. Trey is sort of a newcomer to Washington, but not really. And so for those of you who don't know the position of counselor to the legal advisor, the legal advisor's office is an interesting place to run because it basically has no political appointees in it other than the legal advisor and a special assistant. So the legal advisor, other than the sort of the normal career hiring, about your only hire is your counselor. Harold had a very good counselor with Sarah Cleveland. I had 3 counselors who have taught a number of you all, Paul Stephen, Ed Swain here in Washington, John Harrison. Not always an academic, but often an academic, although there have been some who have come out of private practice. But Jennifer Newstead, I think, is very fortunate to have Trey. You've just heard him, and you can see why. Very balanced, very thoughtful, and so you should watch for more Trey Childress appearances here in Washington. So it's great to have you. Of course, not unknown here to the American Society of International Law, but we're happy to have you in L. My only comment on this one is actually a kind of an L insider's question, which there may be. Probably no one on the panel knows the answer to. There might be people in the room who know the answer. Is as Jennifer mentioned, the U.S. government did file a brief in response to a CVSG, which Jennifer Newstead, the new legal advisor, signed, which basically said, no, not absolute deference, sort of respectful deference, and the court more or less followed what the government said. What was interesting to me was that in the brief filed supporting cert by the U.S. government, it was signed only by the Justice Department and not by the State Department. So the acting legal advisor was not on that brief, and it's unusual, actually, in a case involving the views of a foreign government. I mean, I would certainly want to have the State Department on the brief and not just the Justice Department, so I don't know quite what that meant.
I'll just add two quick comments. One is that I think it is, it's somewhat concerning to have a court in a 9-0 decision say that it's okay for American courts to second guess how foreign countries characterize their own laws. This is not the only circumstance in which that's happening in courts. But this is a blessing of that happening by the 9 justices who have the power to say these things. And I think that just atmospheric notion that you can, as a court, impose your own view of what you think foreign law requires someone to do or not do is a troubling notion for folks who are believers in international law. And the second thing is, it strikes me as we're talking about these various cases today that there's a contrast in the court's willingness, if you think about the travel ban case, to take something like travel ban 3.0 at face value without looking behind it to see what else might be going on. And then you look at the vitamin C case that involves a foreign government's statement of its own position on something, and there's much more of a willingness to look behind it. And that contrast just strikes me as something that shouldn't get lost.
So one question from the audience. And go ahead, please.
So I was wondering, I want to place this question to the panel.
Wait 1 second for the microphone because the video won't pick you up without the microphone.
Thank you. I have just one question and a short comment. How much do you think it mattered that it was the Chinese government vis-a-vis the case had erupted out of the interpretation of UK law or European law by the fact it was the Chinese government and there was a single interpretation that could be manipulated? And this brings me to my comment. How much do you think we're going to start seeing more cases where perhaps the foreign government has a particular interpretation of domestic law that contradicts the decisions from Supreme Court justices or Supreme Courts in the same jurisdiction? Because traditionally we believe that there is one single voice defending or speaking on behalf of the other nation, but there might be different interpretation when it comes to the judiciary's Supreme Courts that might not be even a consensus domestically. I think that's what Justice Ginsburg was trying to get at, that there's no single voice when it comes to interpreting foreign law, as there is no single voice in interpreting the U.S. law here.
Did we have a second question, too?
No.
Can we take them
Yeah,
together?
why
take
don't we
both.
take both questions?
I'm Lourdes Venez. Thank you for your presentation. It was great. And it in some ways relates to what he was mentioning. It's like, who is the authority in the foreign country to determine? Because the same way that you have a sort of legal hierarchy where the Constitution and the law and this and that, you should have a sort of, a clear entity that will really represent what is that foreign country law. Because you mentioned the word different, interpretations or statements in terms of what was the their regulation regarding those requirements of price fixing or something. That's basically is how do we define that? Even if you believe in international law, how do you make it in terms that it's also respecting the values and the principles of it? Thank you.
I think it's a nice question. I'd like to think on the first part about China that it shouldn't or wouldn't have made any difference. I think in the oral argument, what the court was concerned about was turning over the law declaring power of U.S. courts to foreign governments, and basically saying, look, we don't do that in domestic cases. Why would we ever do that in cases involving foreign law? On the second point, Ginsburg in her decision references the fact if the relevant state law, U.S. state law, is established by a decision of the state's highest court, that decision is binding on the federal courts. But views of the state's attorney general, while attracting, quote, respectful consideration, do not garner controlling weight. And she talks about that in the context of the interpretation of U.S. law, but I think, perhaps the next battlefield, in a way, which raises more concretely the issue of international comity, which was before the Second Circuit, which was a question presented to the court, which was not accepted for consideration in the certiorari process, and which is referenced also in Justice Ginsburg's opinion, where she talks about this rule that we're coming up with is based on the, quote, spirit of international comity from the Aerospatiale decision. I think that there still is some interesting wiggle room going forward as to what you would do with a judgment of the highest court of a foreign sovereign if they establish law as something, and whether or not merely respectful consideration is due. I can't imagine bound to defer is due because there's no international res judicata, but whether or not it's something more than just respectful consideration.
Trey, if you believe it didn't matter that it was China, I have a great wall to sell you near Beijing. China is not a rule of law society. And the government can alter interpretations on an opportunistic basis. And what they're really saying here is, if we're not bound to defer to the opinion of the AG of New York, why should we be bound to defer to an executive branch in China, which could be ordered to do it? And if the Chinese government really wants to assert its sovereign interest, order them to do it. Say it's a public act of a recognized foreign sovereign fully executed within its own territory and claim foreign sovereign compulsion with the act of state doctrine. That seems to me to be a correct interpretation here. Now, it's different if you have a ruling of, say, the House of Lords, but then you can actually go back through transparent opinions and see whether it's a consistent interpretation by the courts. And that can be done by amicus brief or by expert legal opinion that's submitted pursuant to 44.1. And I think obviously that should have been laid out in more detail by Ginsburg's opinion. But I think when you look at her test and the factors, that's what she's really talking about.
Should we move it along? In order to move it along, I'm actually going to offer one small comment of my own that I think segues nicely to talking about the Foreign Sovereign Immunities Act. Jessica, you noted that it was troubling to people who practice international law that the court wouldn't give absolute deference to a pronouncement of a foreign country's own law. I actually take the precise opposite view. I think it would be really troubling. One of the greatest, I think, achievements of international law over the past century is the notion that we can hold sovereigns accountable for their acts, restrictive sovereign immunity, the investor state system as well. And I think it'd be really troubling if a company, a country who was on the hook for liability could walk into a U.S. court and say, yeah, no, here you go, we're out, and you have to defer to it. I think that would actually be more troubling than sort of the rule that was announced here. And this brings us to the Foreign Sovereign Immunities Act that John's going to talk about, the Rubin case. It seems like, at least to me, that we're seeing an FSIA case in every term for the past 5 or 6 years. There's been an FSIA, almost as if the court has to check a box to take an FSIA case. 2 for next year, that's right. So turn over to John Rubin versus Islamic Republic of Iran.
Great. So we're bumping up against the 8 o'clock time, so we'll try to get you all out on time to your dinners. So this is Rubin versus Iran, which is, as you heard, a Foreign Sovereign Immunities Act case, and indeed is the 5th case in 5 years. This one has been kicking around for almost 20 years. It is old enough that I filed a brief in it back when I was legal advisor in 2006. I've not been involved in it since then because I would be recused since then. But in looking back, I see that I filed a brief back a long time ago. So this is a case that arose out of a terrorist incident in Israel in 1997, and then was a suit under the terrorism exception of the Foreign Sovereign Immunities Act against Iran for training the terrorists on that case. And as you all know, sovereigns are generally immune for their actions in U.S. courts unless there are certain exceptions. The personal activity exception is the most famous exception, but there's an exception that has been in the Foreign Sovereign Immunities Act for about 20 years that allows state sponsors of terrorism to be sued, which has resulted in lots of litigation against designated state sponsors, Iran, Iraq, Libya, Cuba, North Korea, various others, and most of them against Iran. So this was a case against Iran for training the terrorists. In 2003, when I was still in office, the court here in D.C. handed down a default judgment against Iran for $71 million. And then, as always happens in all of these cases, the hunt is then on for the assets to pay the judgment. And so the judgment holders here went to Chicago, where they found some antiquities that had been in the University of Chicago Museum, not since the time of the Shah, but this is real Indiana Jones sort of stuff, since the 1930s, since they had been found. They had been sent to the University of Chicago to be cataloged and had been on long-term loan since the 1930s, something like 30,000 clay fragments. And so the judgment holders in this terrorism case then tried to attach those fragments so that they could then be sold at auction. And the question was, could they do that? So for those of you who know your Foreign Sovereign Immunities Act, there are sort of two pieces. Not only the first piece is, can you be sued and sovereigns have immunity, but separately, can the assets be attached? And the two are unconnected. There's a different provision in the Foreign Sovereign Immunities Act that says the assets of sovereigns shall be immune from attachment unless there are different exceptions to that. In this case, the legal advisor's office had filed a brief, of course, with the Justice Department in 2006, essentially saying, no, they couldn't be attached because these were on long-term loan for art purposes and not for use as commercial activity. The district court and ultimately the Seventh Circuit affirmed that and said, no, you can't attach these assets. That created a circuit split because some circuits had actually said that if you have a terrorism judgment, then you can, under the exceptions for immunity from attachment, then attach essentially anything you want as long as you have a terrorism judgment. The Supreme Court looked at that. It received another brief from the U.S. government that was signed by acting legal advisor Rich Visek before Jen Newstead came on board, and the Supreme Court affirmed the Seventh Circuit 8-0. Elena Kagan was recused. Presumably she'd advised on it when she was SG and said, no, you can't attach these assets. And it came down to, and this is where it gets a little bit interesting, it is a statutory interpretation case. One of the exceptions to attachment is in 1610G of the Foreign Sovereign Immunities Act, and it addresses when the holders of terrorism judgments can pierce the corporate veil of agencies and instrumentalities of a state. And that change was made in 2008, specifically to reverse a previous Supreme Court decision involving the Bank of Cuba, where the Supreme Court had said, just because you have a judgment against Cuba doesn't mean that you can then go and force it against various agencies and instrumentalities of Cuba, because we in the United States reflect corporate forms. You can't just go and attack. You've got a judgment against Cuba, you can enforce it against Cuba, but not against the agencies and instrumentalities. So in 2008, Congress fiddled, as they often do, and I'll get to this in a minute, with Foreign Sovereign Immunities Act. They added this exception, 1610G, that said holders of terrorism judgments can essentially pierce the corporate veil and attach the assets of agencies and instrumentalities, quote, pursuant to this section, to get the assets of these agencies and instrumentalities. And the question was, did this bit about piercing the corporate veil mean that you could also go against the assets of the state itself? The plaintiffs said yes. What the Congress really was trying to do here was saying if you were a terrorism judgment holder, that you could go against any assets of the state that you wanted. The legal advisor's office said, no, you can't. This really just has to do with piercing the corporate veil. The Seventh Circuit agreed with that. The Supreme Court agreed with that, 8-0, and said, no, you cannot go against the assets of the state. There's no separate provision that says that you can go against the assets of the state. So pretty simple opinion. I'll just make a couple of observations here. One, it will not surprise you, I think that this was a correct decision because they agreed with me. They also agreed with the legal advisor's office and the U.S. government, basically followed the decision. The sort of second point is these Foreign Sovereign Immunities Act cases, particularly the ones involving terrorism judgments, are very difficult for the U.S. government. We get drawn into them all the time. Harold and I have both had to sign these briefs. The facts are always uncomfortable. You often have to side with terrorist states and say that they are immune. The victims of terrorism then come in and meet with us and really beat up on us. I mean, I have really been beaten up hard by, it's usually not so much the families themselves, but their lawyers, who have accused us of saying, we were terrorized once and now we're being terrorized by the legal advisor's office. The reason that we do this is not to protect terrorist states, but because hopefully everybody in this room knows what immunity is all about. We have immunity not to protect other people, but to protect ourselves. We have sovereign immunity to protect the sovereign. We have head of state immunity to protect the head of state. We have diplomatic immunity to protect diplomats. This is often hard to explain, particularly to plaintiffs' lawyers and also to our Congress. But that's why we do it. And so, Harold and I have both had to file a number of these cases. Last couple of points. As pointed out, we have had Foreign Sovereign Immunities Act cases every year for the last 5 years. That started, and what goes back earlier than that to Samantar, but there have been quite a few of them. We had the NML case in 2014. That was the Argentina case about whether you could get discovery against Argentina. Then we had the famous OBB case. That was in 2015 against Austria's State Bank and or State Railroad, whether you could sue Austria's State Railroad. 2016, the famous Bank Markazi case, which has resulted in Iran now suing us before the ICJ. 2017 was the Venezuela case, and then Rubin this year, and then as I heard Mark Feldman say, there are actually 2 cases that have been accepted, one involving Sudan and whether you can serve the country by sending the service of process on the embassy, and then there's a different case involving the international organization immunities of the IFC and of international organizations generally. So they've been taking a lot of these cases. They're quite interesting. I don't think there's a particular method to their madness other than that there have been circuit splits, and they've come out different ways. In some cases, they have ruled in favor of sovereign immunity. In other cases, not. Here's the last point, though, to watch. And this is something that is troubling to me. The reason that we had this provision, 1610G, was that Congress had changed the law again. What happens in these cases under the Foreign Sovereign Immunities Act is that plaintiffs sue, they lose, and that's then not the end. That's just a extension. Then you go into extra innings, and they go to Congress to change the law. And so the Foreign Sovereign Immunities Act has been changed a dozen times to fidget with particular pieces to ensure that plaintiffs can then win their cases all the way down to listing civil action numbers. When I was legal advisor in my last year, 2008, this particular change on attachment was made along with a number of other changes And the changes were so dramatic that it actually allowed Iraq to be sued while we were trying to reconstruct Iraq. Legal advisor's office ultimately had to recommend to the White House, this was included in the President's National Defense Authorization Act, a unvetoable bill. We recommended to the President that he veto his own National Defense Authorization Act in the middle of a war, and he did. You can imagine who it came down to explain to the White House why the President had to veto his own National Defense Authorization Act, because Congress had stuck in some stuff fidgeting with the Foreign Sovereign Immunities Act. That was actually a tough sell to the White House, but they ultimately understood, how important it is that we get this right. So, in fact, the President vetoed his own National Defense Authorization bill because of this very provision that we are talking about here. He was mostly concerned about Iraq, and then Iraq was given a waiver and it was repassed. So, I just end with the point is, just because plaintiffs have lost this particular case, and again, the facts are horrific. Every one of these briefs that Harold and I and soon Trey will be advising get to sign, the facts are horrific. There are real dead people and tragic cases, but when we actually start going and fidgeting with the foreign sovereign immunities of other states, it does cause problems for our own country. And so, we will see what ultimately happens. Will this be the end of it, or will we now go back and see an effort to actually reverse in legislation Rubin v. Iran?
So I'm being told by our gracious host that we are at time, but I want to ask, is there one person on the panel who is really compelled to make a comment on Harold? Will be our final comment.
So I agree with John. It's a correct interpretation of the law that exists, and that law will be changed by Congress. So it's good for a little while. It's a unanimous opinion, but it was done in February. It was done by Sotomayor, who had the strongest term in international law. I think the general pattern has been that the court grants cert on circuit splits on FSIA cases and grants to reverse. And in this case, the SG's office, joined by the legal advisor, asked for them to move a different case up, but they wanted to take this case. I think that the
that's
no, I'm sorry, that's Sudan
Harrison
versus Harrison, right? I think on the merits, the University of Chicago should give these things back. I mean, Yale gave back the Hiram Bingham stuff that was stolen to Peru. But I think what this really does is
How are you on the Elgin marbles?
Stolen. But this goes to the point that Mark Feldman made about the Alien Tort Claims Act. The Arab Bank case continues under the Anti-Terrorism Act. Everything that you describe as a problem is going to go on anyway, on remand. The real question was whether financing of terrorism is a tort in violation of the law of nations, and that's what Sotomayor would have remanded under Sosa to determine. I think that these anti-terrorism cases, Congress has enough will to change the law, that they're emerging as a sui generis group of cases where there's a bipartisan support for the plaintiffs, and Congress will enact these provisions, and it's increasingly an area where our foreign sovereign immunities law is moving away from the state of play in the rest of the world. And so we'll see when that disparity comes and becomes more strongly realized.
Please join me in giving a round of applause to our excellent panelists.